स्टडी IQ IAS, अब तैयारी हुई अफोर्डेबल।
Welcome to StudyIQ's initiative, the podcast. I am your host, Dipansh Moorjani. So tighten your belts because it is time for the podcast of the day. After discussing directive principles of state policy in detail in our last episode, our topic for discussion in today's episode will be directive principles of state policy versus fundamental rights. Sir, we are curious to know why there has been a dispute between fundamental rights and DPSP.
Before discussing the dispute between fundamental rights and DPSP, I would like to talk about fundamental right and DPSP in very short. Fundamental right and DPSP, which is directive principles of state policy, are essential components of Indian Constitution. The fundamental rights are the rights guaranteed by Constitution to individual of India. The directive principle establish many welfare state concepts. The conflict between fundamental right and DPSP develop when the state is required to apply a directive principle that infringes citizens' basic right. We will try to understand with example. For example, if fundamental right is providing a safeguard for non-discrimination on the basis of gender, caste, religion, sex, place of birth, etc. However, to implement a directive principle, state may require such laws which will cater the upliftment of weaker sections, eradicating economic inequalities, etc. In this situation, there might be a conflict between directive principles which state is going to follow and fundamental rights for an individual.
Sir, can you throw some light on constitutional provisions of fundamental rights and DPSP?
Now we will talk about constitutional provisions of fundamental rights and directive principles. Fundamental rights are the basic rights provided to citizens by Constitution. These rights are incorporated in Article 12 to 35 of Part 3 of Constitution, and it ensures civic liberty to all citizens so that they can live in harmony. They also keep the state from taking away citizens' freedom. Fundamental rights pertain to all citizens regardless of race, caste, creed, gender, religion, birthplace, or other criteria. Part 4 of Indian Constitution, articles ranging from 36 to 51, contains directive principles. They include directions or regulations that the state must follow while enacting laws and policies. The legislative and executive activities of a state are carried out in accordance with the directive principles of Indian Constitution. The directive principles are similar to the instrument of instructions listed in the Government of India Act 1935.
Sir, for any UPSC aspirant, fundamental rights versus DPSP becomes a very important topic. So, can you throw some light on cases which solve this dispute? Basically, students want to understand the stand of the Supreme Court of India when it comes to fundamental rights versus DPSP.
The dispute between fundamental rights and DPSP has been solved through various Supreme Court judgments. In this regard, the first important landmark judgment to address the dispute between fundamental right and DPSP is Champakam Dorairajan case. The Supreme Court addressed the issue between fundamental rights and DPSP for the first time in 1951. Srimati Champakam Dorairajan was a Tamil woman from Madras. Because of communal government order that offered caste-based reservation in government policies and positions and college seats, she was denied admission to get into a medical college in 1951. The Madras Presidency passed this order of government order in 1927. The Supreme Court's first major decision on the topic of reservation was in the Champakam Dorairajan case. Champakam Dorairajan case resulted in the Indian Constitution's first amendment. This was the case that was in the Supreme Court at the time when the Lok Sabha was not even get created. The Lok Sabha was established in 1952. Champakam Dorai Rajan case highlights the point of contention was between Article 16 subsection 2 of Fundamental Rights and Article 46 of Constitution under Directive Principles of State Policy. According to Article 16 subsection 2, no citizen shall be ineligible for or discriminated against in respect of any employment or office under the state solely based on religion, race, caste, sex, descent, place of birth, residency, or any combination of these factors. And according to Article 46, in conflict with the prior article, the state shall promote the educational and economic interest for weaker parts of the population, particularly the scheduled caste and scheduled tribes, and safeguard them from social injustice and exploitation in all forms. According to Supreme Court, Article 37 specifically states that the directive principles are not enforceable by the courts. The Supreme Court ruled that the Constitution's chapter on fundamental right is sacred and that directive principle must be consistent with and subordinate to the chapter of fundamental right. In simple words, in this Champakam Dorai Rajan case, Supreme Court have kept fundamental rights above the DPSP. This signifies that directive principles have been given precedence over the fundamental rights. This went on for a decade and a half. And in cases like Qureshi versus State of Bihar and Sajjan Singh versus State of Rajasthan, the court confirmed these positions again and again. However, the next important judgment of Golaknath case, a significant case, occurred in 1967. The case was Golaknath versus State of Punjab. In this case, the Supreme Court formed a bench of 11 judges for the first time in the history of Supreme Court. In this decision, the court ruled that fundamental rights cannot be restricted or reduced to execute directive principles. The government was forced to modify the Constitution as a result of this ruling. The 24th Amendment Act of 1971 altered Article 13 and 368 of Indian Constitution. This change clarified that Parliament has the authority to amend any portion of Constitution, including fundamental rights, and that the term law in Article 13 does not include a Constitutional Amendment Act. However, the next judgment in the series is Keshwananda Bharati case. The Supreme Court declared in the Keshwananda Bharati case that Parliament might change any element of the Constitution, including fundamental rights, but it could not undermine the Constitution's core structure and gave the doctrine of basic structure. To overturn the Keshwananda Bharati case decision, the 42nd Amendment revised Article 31 subsection C to state that no law giving effect to the policy on the ground is inconsistent with or abridges any of the rights guaranteed by Article 14, 19 and 31. In this series, the next judgment is Minerva Mill case. The 42nd Amendment of the Constitution broadened the scope of fundamental rights. The Supreme Court, however, threw down these restrictions in the Minerva Mill case versus Union of India because it altered the Constitution's fundamental framework. Part 3 and Part 4 of the Constitutions are balanced according to the Supreme Court. Giving one absolute precedence over another will disturb the Constitution's balance. This restored Article 31C to its previous position, stating that law would be covered by Article 31C only if it was made to execute the directives under Article 39B and 39C and not any of the provisions in the Part 4.
Sir, after understanding different observations of Supreme Court, we are eager to understand the conclusion that we can take from these cases.
As an aspirant, we need to understand how the directive principles and state policies are balancing each other. To protect the rights of people, a balanced relationship between fundamental right and DPSP is very important. The judiciary has also contributed by interpreting the right to health, education, etc. to make some DPSP clause effective. DPSPs are therefore crucial for understanding the fundamental rights, and together they serve as a constitution's conscience, which is trait of country that values growth. For a democratic country like ours, striking a balance between the two becomes very crucial. And in Supreme Court judgments, one of the judges gave an quotation that fundamental right and DPSPs are two wheels of one chariot, and chariot cannot move without any of the either.
So we can say that directive principles of state policy and fundamental rights both are an integral part of our Indian democracy. Sir, thank you for your explanations. Dear listeners, we will conclude this episode here itself. In the next episode, we will be back with another topic. Till then, keep studying and stay connected with StudyIQ. You can listen to StudyIQ Presents, the podcast, on various audio streaming platforms such as Kuku FM, Hubhopper, Spotify, Apple Podcast, Google Podcast, etc. All the links are pinned in the comment section. Thank you.